Hello everyone, it's Rick. It's Thursday, June 29, 2017. If you need to contact me, it's rick0327@me.com. And this might be a part 1 video. I was doing a little analytic check of my channel yesterday, and I discovered that the average duration of view is only 6 minutes. So that means these videos that I'm making that are like 20 minutes long, the average person just sticks around for 6 minutes because they're probably not hearing that silver bullet thing that doesn't exist. Let me tell you something. If somebody had a quick way to get out of this with a piece of paper, it'd be blasted all over YouTube. All right? There's a guy who claims he had it dismissed, and it's some administrative law judge check-in dismissed, but he doesn't show the whole thing, doesn't show what he sent in. And let me tell you something, judges don't check off a box that dismiss, because nobody's able to rebut anything. What am I going to rebut? A check mark? He used blue ink. He didn't use black ink in a check mark. So, it doesn't exist. Trust me. You have to use this. You got to use the law. And that's what I'm doing when I'm speaking to you guys for a while, and then I tell you these little stories they're called anecdotes that apply. Yeah, I go on my little rants once in a while, but most of the things that I'm telling you, they're for a reason. You know, I know people are busy, but the other day I made a mistake at the 19-minute 40-second mark, and my man James caught it and told it to me, and I had to make that quick video because I said partiality when it should have been impartiality. The courts are supposed to always show you the appearance of impartiality. We know that they don't. But I've been doing my homework, and I discovered that the Supreme Court says that in every petition there has to be an injury in fact. The injury in fact in fact means that it actually exists. Now, a child support injury, if you want to call it an injury, for non-payment of support, it's theoretical. In theory, your non-payment caused the baby mama to go on welfare. But let me ask you something. Is welfare considered an injury? No. Actually, welfare is a remedy. Remember, I've said this in the past. Those of you that are new to my channel, I've always said that, you know, the women are never, if you're not paying child support, they always have the option to go on welfare, and the children are fine. The whole basis is, you know, of an injured party for non-payment of child support is because the children's financial needs aren't being met. Listen, as a police officer, I see plenty of kids on welfare wearing very nice clothes. Now, I'm not saying that, you know, it's okay. I'm saying you should still support your children, but it's very difficult for the petitioner, which is the mother or husband, or my favorite are these child support agencies who are the petitioner, or in Texas it's the Attorney General's office. But how is the Attorney General or the child support agency going to be able to show an injury in fact? Where is the injury you're causing? You can only cause a person, a man or a woman, an injury. You can't cause an injury or damages to a corporation or a governmental agency. And then, based on the injury in fact and the causal action by the respondent, which is you, me, based on that evidence, then the court has the ability to redress and remedy. It's a three-pronged approach based on the Supreme Court. Injury in fact. The injury in fact is caused by you, by an action or a non-action. And number three, based upon that evidence, the court must be able to reach a conclusion that it can remedy the redress. So now, with that, where are these child support phonies, at these hearings with the non-judicial people and even the administrative judge or whatever? How are they going to prove that you caused the injury? How are they going to be able to do that? They can't. It's impossible. So how are they going to enter a default judgment then? That means on the default judgment, before you're ever, let's say you didn't show up, right? You didn't show up. That petitioner still had the burden of showing an injury in fact. So what do we do now? Well, we're going to file paperwork demanding to see the evidence introduced that caused the injury in fact. Okay? We're getting there. And just so happens, I'm working on that paperwork. All right? So it's something to think about. Oh, I'm only at the 7-minute mark, so let me shut this video down. I'll talk to you guys later.